and welcome to The Presumption. I'm Sara Azari, joined by Jim Griffin.
Hello, Sara.
And Matt Fondler.
Hey, guys. Fondelier. Spelled
Fondelier.
Spelled Fondelier, pronounced Fondelier. It's the story of my life.
You know, Sara and I have done so many of those fondling cases.
Yes, I know. My middle name is William, so my full name is actually Matt Will Fondler. I have really owe my parents so much for that. But no, it's Fondelier. But it's
my Lord, I'm sorry.
Hey, no problem. I'm here.
It's also because half the time I'm not wearing my glasses, and when I tag you in posts, you know, the I and the L are like, you know, I'm just constantly. Anyway, all right. Well, awesome. Today, I'm excited about this episode because there's been so many developments in the Brian Kohberger case, the Idaho4 case, quadruple murders. And we have a very special guest joining us following a crime time between me and Jim. So, Jim, can we get started with all the latest developments? The first one being that the court recently modified the non-dissemination order, also known as a gag order. And also,
No. If you don't mind, Sara, before we get into that, I want to thank you for giving up your time on Good Morning America 3 to promote the Presumption podcast. I mean, you made that available to us. I walked on the set of Good Morning America, and my big ass head was taller than I've ever seen it, and I was ready to run for the hills. It was the most amazing experience.
So Matt, listen to this. So it's like you know, I don't know. I didn't take a red eye. I flew Sunday, but then I sat with a dog on the tarmac in Dulles for like 6 hours because they diverted us. It was like a whole shit show with the flights. Jim was taking a red eye from Colorado, and I was worried that he's not going to make it, but he made it, thankfully. And I'm half asleep, and I walk on the set, you know, and Jim's like, hot damn! And I'm like, what? Just like,
I'm from Podunk, South Carolina, and I'm walking on the set of Good Morning America, and who do I see?
And it was huge. I mean, they really did us a solid. And it was just because I think I think the topic resonated, the whole, you know, idea of true crime genre and the impact on the presumption. So the topic really is what, you know, resonated with the producers. And I was so thankful that they gave us so much time. It was an 8-minute segment, Matt, which, as you know, is really valuable real estate on TV. And so, but I was so exhausted that you could put, I don't know, big ass whatever in front of me. I would not see it. And Jim was just like, hot damn. I'm like, wait, what? Right. Anyway, it was, I'm very thankful to.
But no, thank you, Sara. That was you had already booked that segment for some time in advance, and I appreciate you.
Oh my God. No, my pleasure.
The presumption up front.
Yeah, the presumption is a priority in my life, and I'm grateful to you for doing this with me. And I also just want to thank Teresa, Eva Pilgrim, DeMarco Morgan, and Kat for having us on GMA3. Okay, so
and anybody who's discovered our show through GMA3, welcome. Thanks for listening to our show. Appreciate it.
And spread the word so other people also subscribe. So the gag order, Jim, there was a modification of that. Plus, I think there was something about whether or not cameras will be let in the courtroom for the trial. Can you tell us all about that?
Yeah, so there've been a lot of developments. I mean, one was the gag order, if you will, and there was a big hearing. There's a big ruling by Judge. I love that name, Judge. He is, but basically there were two components. The biggest issue that the press had moved to intervene and tried to limit the gag order, and it turns out the gag order originally entered into was agreed upon by the state and by the defense, and it was a gag order. You could not talk about anything to do with the case in the public. Period. End of story. Shut up. Nothing can be said. Now that is over. That's overkill. And one of the lawyers for the victim's family, Shannon Gray, objected to that, and then some media outlets objected to that. They had a big hearing, and the judge modified the order and allowed for limited public disclosure, and it basically tracks the rules of ethics adopted by most every state and by the ABA, American Bar Association. And what I found significant was the judge also included Shannon Gray, the victim's lawyer, within the confines of that dissemination order. And so there's some things that they can talk about, mostly in what's filed in public record, and other matters. I mean, there's more broad discussion available. It's still restrained. It's similar to what we've been operating under in the Murdoch case and in other high profile cases I've ever been involved in. And so, but Matt, I want you to pull up a decision cited by Judge and from the U.S. Supreme Court back in 1966. I was 4 years old in 1966. Matt, I don't think you were even a sperm running around in 1966.
Me neither.
So, in 1966, in this Maxwell decision, this U.S. Supreme Court says, quote, "From the cases coming here, we note that unfair and prejudicial news comment on pending trials has become increasingly prevalent."
Good Lord, if they only knew what's going on today.
I know that was in 1966.
Right.
And in 1966, there was maybe 3 network channels and some newspapers. Yeah. And so now, so anyway, you can take that down, but I found that very interesting. But Judge loosened the restrictions. He put them in conformity with what's readily accepted around the country. And, but he did point out that the earlier overburden restrictions was by agreement. And so that's where we are on.
There are 2 things that I found interesting, Jim, with respect to that issue was there was this, what I call a Dear Ann Taylor clause. Ann Taylor is the public defender that represents Brian Kohberger.
Who I'm a big fan of, by the way. I think she's doing an excellent job.
Me too. So the order said that a lawyer can make statements that a reasonable lawyer would believe it requires to protect a client from substantial undue prejudicial effect of recent publicity not initiated by the lawyer or his client. So this is directed to the defense because, as you and I have talked about, gag orders harm the defense. Usually there's these law enforcement leaks that are pro-prosecution. And so here he's saying, hey, if it's not something that you spread and you need to address media, you can do that. But do you agree with me, Jim, that you pretty much have to kind of say no comment? And your words have to be so carefully chosen if you're going to address something that it's just like
it's dangerous, but it's important. And so, I mean, that comes straight from the Rule of Ethics 3.06. Yeah. And I got to tell you, I find that rule comforting whenever, I mean, I've had a lot of high profile cases and a lot of press coverage, and I hate saying no comment. I hate saying no comment in the press.
Because it almost looks like you're being evasive. Like
I do all I can do not to say no comment.
Yeah.
But I'm careful with what I say because, when I think through it, that I want to be able to ever challenge to say, well, I'm responding to what's in the public domain. And so, I mean,
yesterday, one of my colleagues who was the attorney for Rob Baker in the Sementelli murder case here, the love triangle, who the guy pled guilty and got the LWOP. He was texting me and I was just walking out of the jail and I'm like, can I call you later? And he said, no, it's really important. It's time sensitive. So I call him and he says, hey, the other 2 defense lawyers are giving a statement to the press. Should I do it? I mean, my client's already done and, but I just don't want to do it because, he pled guilty and it's like his right, but like, how, and I said, you got to do it because if you, especially if the other 2 are making a statement and their client's going to trial and then you're missing MIA, it just is it's like no comment. The public will take that as like, there's something nefarious going on. I don't know. I agree with you. I think you have to say something. What about the fact that Ann Taylor asked the court to take judicial notice? I just want to tell our viewers what judicial notice means. It's about the court establishing a fact, like the sky is blue. South Carolina is in the United States. I mean, something that is just unequivocal, it can't be disputed. And Ann Taylor asked the court to take judicial notice of press coverage. Where do you think she's going with that, Jim?
I think she is maybe laying the groundwork for a motion to transfer venue, maybe laying the groundwork for her motion to dismiss the indictment in some form or fashion.
Yeah.
And but it's hard to know.
Yeah.
I don't. I've never seen that before, but I'm not going to second guess her at this
Yeah, I
point
mean,
in time.
she's crossing all the T's and dotting all the I's for sure. The
Right.
last thing I want to say about the gag order, which goes to your point, Jim, was that the court acknowledged that the initial one was arguably overbroad and vague, but that the new sort of revised gag order is more narrowly drawn to prohibit statements that have I'm quoting it, substantial likelihood of materially prejudicing this case. Now, I just want to leave our viewers with this. Whenever you read the word substantial, material, and prejudice, I mean, it has litigation written
Yeah.
all over it, because those are the
Okay.
words, those are the magic words that bring us to court, and we have to litigate on the meaning of that within a context of specific facts and circumstances. So it still
Yeah.
doesn't mean it's bulletproof and that, there's going to be a clear parameter on this gag order, but it's better than the one before, right?
Oh, for sure. But I really do think the news, the headline of the day, which has not made the headlines, is the fact that Judge included Shannon Gray, the
Yeah.
the plaintiff's lawyer for the victim's family, in
Hmm.
the restrictions on the order. I mean, we had a whole Murdoch economy of plaintiff's
Well,
lawyers
I know there was a
who.
certain lawyer that you were trying to gag. I know that. Hmm.
Well, I mean, it's you have these lawyers out there grandstanding on behalf of victims to promote their own practice, and I don't know Shannon Gray. I'm not saying he did that, but it is an irresistible temptation to lawyers who are making money on contingency fee
Well,
cases.
he's made a lot of statements that tend to infer guilt of. I mean, not even infer, pretty blatant that like Kohberger is guilty and he deserves the death penalty, for example. He's made
Yeah,
statements
and
about.
so it's easy. It's easy for some guy out there who's not in the trial, not going to be at the courtroom, and not going to be standing there when the jury turns a verdict to to mouth off like that. And I'm so thankful that
Matt,
Judge said, "Don't do it."
Do you like how Jim says judge, judge? He keeps saying it, judge,
Yeah.
judge,
I
judge,
love it.
judge.
When I was in high school, I took a wood shop class, and my teacher's name was Mr. Saw, and it doesn't get better than that, you know.
All right. Well, okay. I'm going to
So
talk about
so now we're going to talk about officer's report. Is that
no. We're
Roger,
going to talk
Roger.
about alibi.
Roger, Roger.
So the defense filed a request to extend time on Kohberger's alibi. Okay, so I keep looking for those of the viewers who are watching our podcast on YouTube. I apologize. I don't want to miss anything, so I have my notes here. An alibi isn't an end all be all of a defense. Okay, I think we all look for it because we want this easy way out. We want something that's really understandable and digestible. But two things can be true. Most defendants don't have an alibi, Jim, and they could be found not guilty. They could be acquitted. So we don't know if he has an alibi. And, the alibi is not just about the 15 minutes around this window of the quadruple homicide. The alibi in this case is far broader because they reference, just based on what we've seen, all of these times where he's in his car in specific locations, pinging cell towers. You and I both know that cell tower pinging is subject to triangulation. There's a lot of unreliability there. But let's just say it all checks out. For them to be able to put Kohberger in a different place, they have to know all of those things. It's not just the 15 minutes that during which supposedly he was in this house on Kings Road. There has been 52 terabytes of information that's been produced, and more is coming. And I think it's very complicated to go through all of this and then put together an alibi if he has one. Next thing I want to say is that it's
Well, so let me stop you there. Newsflash for all of our listeners is that clients lie to their lawyers all the time. And
right,
so the lawyer is not doing his job if he accepts the client's word for
right,
where he was on a certain point in time when the client says that. I mean, the client's obligated to get all this backup data to cross check to see if what the client's saying is inconsistent with what the data
right,
says.
right. So
And
so often people come in not telling us the truth
it's
or
shocking, I know, but it happens.
lying by omission, which is also a form of lying. And then when all of this comes in, and I literally bring the client and anybody that he's authorized me to, obviously communicate with into a conference room with a big projector or a whiteboard. And I literally, as though I'm in trial, I present the evidence and I have a
Right,
nice conversation about how this plays out in front of a jury. And you're right. Sometimes it takes months and years before the client, has that come to Jesus, come clean moment where we can then start talking about alibi. And most people don't have it. But the one last thing I want to say about this is that it's an affirmative defense. And so even beyond the notification that you give about there's an alibi coming, right? You also have to produce what substantiates that because the prosecution has to have the ability to investigate that. So there's no surprises. Just like we're entitled to the prosecution's discovery and the evidence to prepare our defense. We can't just surprise and spring out an alibi. So we have to, we have to give them sufficient notice and also give them what proves that alibi.
right.
It's not just like, oh, my client was in bed or whatever. It really shifts the burden, right, Jim? So leave you with this. Defense is to dismantle the prosecution's case, and then shifting the burden to themselves to prove up an alibi may not always be the best defense. So you sometimes have to pick and choose.
For
Back
sure.
to you on a motion to stay the proceedings. What's that about?
Yeah, so the defense has filed a motion to stay the case. Essentially, the deadline's to file a motion to dismiss the indictment until they get the grand jury transcripts. So apparently, the defense counsel intends to file some dismissal motion, and they need the record of the testimony and information that was presented to the grand jury. They have not yet been provided that, and they're asking time to get it. And so it's I wouldn't read too much into it. I
But
don't
how
think
often
it
does
does.
an indictment get
Yeah,
dismissed?
yeah, hardly ever. I mean, the
Right.
standard is so low, you don't really get to look behind the indictment. You can come in and show there's outside influences or something, but
Yeah.
I've never seen an indictment dismissed.
Well, yeah, and grand jury indictment is the equivalent of a preliminary hearing. We have a lot of preliminary hearings on the state level, on the federal level. Obviously, you and I both know it's mostly grand jury indictments, but on the state level, in LA County, at least we have complaints. And so we're entitled to a probable cause hearing. Grand jury is also a probable cause hearing. And the standard, like you said, is so low that I always tell my clients, it's not about walking out with no charges. It's about reducing the charges or just
Right.
simply making a record for impeachment at trial. Speaking of the grand jury materials, it seems like the parties have agreed. They've agreed to a lot of things, which is typically what we do because not everything's a fight. And we like the saying goes in the legal industry as a whole that criminal defense lawyers and prosecutors are far more civil than civil litigators, and that's very true. We tend to cooperate, and so the grand jury materials is among some of the items that the prosecution has agreed to provide to the defense. That is actually not a favor or a gift. Idaho rules require grand jury materials. So I was on TV with somebody who said, oh, but in federal court, we don't get them. And I said, yeah, but in Idaho, it's actually under their discovery rules that the defense gets to get it. So apparently that's coming for the defense. Now, what I thought our listeners should know is that it's significant because obviously the defense gets to see what incriminating information was presented and also whether exculpatory information was presented because the defense has said many times in their filings that there's exculpatory, this is exculpatory, that's exculpatory. And so what did they present to the grand jury? And Jim, to your point that it doesn't get dismissed, the indictment, if they were to find that there's some significant exculpatory evidence that may have resulted in a no bill, then that could be a reason to kick the indictment, right?
Sure.
Okay.
Well, it's kind of hard. Again, I've never seen it, but
But they'll just re-indict. I mean, that's not a big deal. They'll
well,
just go
that's
back.
right. There's no question. There's no
There's
question.
no prejudice. I mean, they'll just go back and get a new grand jury and do what they're supposed to do the first time. So, but I mean, that's one way to get. Okay. We're going to talk about the demolition of the home. The Kings Road home where the quadruple homicide occurred was donated by its owner to the University of Idaho. It is not on campus. It is off campus in the vicinity. This is a college town, so the entire town is pretty much run by the university, and it's on Greek Row. And the university, now the fall semester coming up, is going to demolish it in August. And neither the prosecution nor the defense are objecting to that demolition. I have a really hard time with this because I know you did a jury view of Moselle and Murdoch, and I know that we don't always know when we need to get the jury out there and make a motion for jury view. What do you think about this? This is outrageous to me.
Yeah, I don't understand why the defense is agreeing to this. I just
They're just not objecting. They're not objecting.
Well, that's right. They're not objecting, and perhaps they're waiting until to make an argument down the road that that you should get an adverse inference because the state voluntarily just destroyed the evidence. I don't know. I think it's very important for the jury to know how close encounter the location was. The one witness who walked by the apparent perpetrator, how close contact that was. How
Right.
close were they to the murders?
Yeah.
And there's a dog barking, and
There's
so
all kinds of temporal and distal uh, aspects of this case. And the idea that there's one guy, Matt, one guy went in and slayed 4 people silently and snuck out. And there's like a DoorDash guy bringing food. I mean, it's just like, how, I'm not saying it's not possible, but the plausibility to me is questionable. And so you're not going to get rid of the place that the jurors can go and actually see for themselves whether the testimony fits the physical environment. I just don't see why you wouldn't object. It's crazy to me.
It doesn't seem like that should be legal. Like if we're still, trying this case to get rid of the scene of the crime. I mean, I've written true crime stories too, where that has happened before. And it seems like something sneaky's happening.
well, Matt, one thing that I've read, because I'm curious about this, I've read, not to say it's true, but that there's some thought that the college wants this house demolished because it's bad for business,
Of course.
and
Right,
that
I get that,
the college is a big economic engine for the community, and so the DA doesn't want to.
It's all about the money. I'll tell you something. It's all about the money because you look at Parkland in Florida, 5 years later, 2 trials later, is now when they're letting the families go in and take a last look before they demolish it. It's just not what happens. And like you said, Jim, the state and the prosecutor working for the state, this particular prosecutor, I forgot his name, I think Thompson or something. I just read an article about him. He moved to Latah County at a younger age. He's been there for 43 years or something like that. Latah is his heart. He's not just another prosecutor in this county. I mean, he really takes his job and the county and the state very just as serious as you can possibly, take it. And so this is a guy who probably defers to the university, which is the state.
Right.
So the last thing, and this is a little bit more entailed, so I need your help on this, Jim, is the discovery rulings. Seems like a lot of what the defense was moving to compel production of has been produced. There are 3 items and then I say plus, that the court specifically ordered and said, you gotta, and Ann Taylor said, you know what? Just to be clear, we don't think there's anything nefarious going on. It's not like we think that they're hiding the ball, but they need to produce the stuff to us. And the court essentially named three requests that the defense had made. The first one is it has to do with the analysis information, reports, etc., of law enforcement experts. The defense was saying, you can't just give us raw materials. We have to know how you arrived at a particular conclusion or finding. We got to know your methodology. And to me, I think what was shocking, Jim, is that, the FBI just does not want, it's similar to the IGG thing. They just don't want their methodology out there. And as I said on a previous podcast episode, there are NDAs that the FBI requires law enforcement to sign to keep their methodology a secret, for lack of a better word. But the court said, no, you can't just dump a bunch of raw data. You've got to give them the reports about the methodology. So what is your response to that, Jim?
Yeah, so that first category is the CAST data, C-A-S-T.
Yes.
CAST is cellular analysis surveillance team, and basically it's cell phone analysis. And so what it appears to me, and I've dealt with this in so many cases, is that the state has given the dump of the underlying data they've obtained from the cell phone towers and the search warrants, but they've not given the FBI's analysis of that data. And that happens all the time. But they will give it, but they wait till like the last minute to give it because
they don't want you to go and do an analysis independently.
Right. And they don't want to be wrong. And so they don't want to, some new information come out. So they keep holding it, and drop it on you at the last minute.
But it's like me giving you a shoe with no lace and going, just go to the gym and have a nice workout. It's like, how am I going to keep this thing on my foot, right?
And,
it's kind
of and so what the judge says is you got till X date to produce it, which is a good ruling. Now, just so we could probably do a whole podcast on cell phone analysis, but what this data is there. You get two types. One, you can go to the towers in the area, and you can get every phone that hits on the tower in the area or the towers at certain points in time. Yeah. And on the other end of the equation, you get a subscriber number, and they have it here, which would a number associated with Brian Kohberger, and you find out what towers his phone is hitting, and so you can track that. But it's not that accurate. It's not wide range of miles, and so the most accurate information comes from the cell phone with the GPS location data. But because they didn't seize that until months later, it's all written over, and there's nothing on there.
Right. And you know what? I've said this on the air. I had a case where I was able to, so there was triangulation between towers. My client was, and I'm speaking of alibi, it was an alibi case. My client was 28 miles away. So, and I think I heard Mark OMara say he had a client with like 30 miles or 20 miles. Anyway, it's not unusual that it's unreliable. It's unreliable. And you know what? You just gave me a really good idea, Jim. I think we need to have a cell tower expert at some point when we know more in this case about that aspect of it. We should talk to somebody. Okay. The next thing is the car. The car is material to this case. And I argue that the car is the suspect because we don't know who was driving the car. And we keep hearing about white Elantra. And then first it was like a 1 year make and model, and then it became a different year make and model. And the car is absolutely material, to the preparation of the defense. And I'm like, no, Brian Kohberger is not the suspect. His car is the suspect. And so that request, I think it's request number 4, basically it's that the communications between experts and the identification regarding the identification of the car, its make, model, and year. The defense has asked for that. It's critical because that's
Yeah,
one of the ways they identified him.
yeah. So Sarah, originally the forensic car guy, whoever that might be, I just keep thinking, I love the car guys on NPR, and I think that's probably who these guys are.
Yeah.
Car Talk. If you ever saw that, it's a
Yeah.
great show. But so they've got something like that at the FBI, and they show these surveillance videos of a vehicle, and the forensic car talk guy says looks to be a certain body style between
Yeah.
the years 2011 and 2013.
Mm-hmm.
Well, then once they start focusing on Kohberger and they realize he has a 2015 Elantra, then the 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 guy changes his opinion and says, no, it goes from 2011 to 2016. So they pick up his 2015 year.
Mm-hmm.
And so what the defense is rightfully saying is, who is this guy? What are his credentials? And why did he change his mind?
Right.
And they have absolutely every right to that.
Absolutely, because it goes to the accuracy and reliability of the evidence
Yep.
against the defendant. The
Yep.
last thing is, look, the ends don't justify the means when we're in a court of law. Again, the FBI is apparently refusing to provide full information regarding use of cell phone technology investigative tools. This is like sort of like the Fourth Amendment rights to be free from illegal search and seizure by the government. Of course, we want law enforcement to use every available tool to apprehend perpetrators of crime, especially this kind of a crime. But the defense is entitled to it to be able to, for the defendant to avail himself of his Sixth Amendment right. So the defense is pointing out in this one, I think it's request number 109, that the information sought formed the basis of search warrants, which means it was relied upon for probable cause. And so,
Right.
if that's the case, then it's relevant and it's material. And then my question, Jim, is was that also used in grand jury proceedings? Because it goes to probable cause.
Sure.
Basically, the defense is entitled to assess the basis of the probable cause to determine whether the search warrants were valid and whether there is a basis to challenge them. If they were illegal, then all evidence that flows from those warrants must be excluded. And law enforcement shouldn't be permitted to apprehend people with secret tools that presumptively innocent people cannot challenge. The last piece is the order to produce training records of 3 specific officers. So the court said that according to Rule 16, the discovery rule in Idaho, the defense had established a substantial need for the records by clearly articulating the role each of the officers had played in the investigation. Remember that there was also a Brady and Giglio notice in this case as well.
Right.
Relying on case law, the court held that those records are relevant to potential suppression issues to help prepare for examination or cross-examination at trial, or to argue for the admissibility or inadmissibility of evidence gathered by those officers. So that's why the prosecution has to turn over these training materials. It's not unusual where I practice. I don't know about where you are, but
No. It's very unusual where I'm from.
so
To
for
get
us, there's a difference between training records and personnel records. So if we're talking about personnel records, which would be complaints and discipline, like the Brady Giglio issues, we got to jump through a lot of hurdles. We call it a pitches motion, but this is not that. This is the training materials. And we have to remember that one of these officers who was doing a very important analysis, forensic analysis in this case, was out training for that analysis. He took like 3 weeks off to go get the training. I mean, this is exactly the procedural type of stuff that, we challenge that goes to reliability of the evidence. So of course the defense is entitled to it, right?
I'm one of the components of the training records was, how do they interview witnesses? And I mean, my God, I've never gotten such a thing. And I'm just saying that because I'm glad they're getting it in Idaho. And I just want to put in a pitch for the public defenders in Idaho and around the country. People who are appointed a public defender, you hear them say, I got a public offender. I got to tell you, and these folks in Idaho are proving it. Public defenders are excellent lawyers. They are committed lawyers. They're in it for the right reasons. They are overworked and underpaid, and they don't have the resources. But if
Yeah.
they had the resources that private lawyers have, I mean,
Some
these
of the
lawyers are doing an
smartest
excellent
lawyers I
job.
know. Some of the
They're doing an
smartest
excellent
lawyers
job.
yeah, and some of the smartest lawyers I know are public defenders or former public defenders. Here they call them public pretenders. So offenders, pretenders, it's all offensive. And
It's all not true. It's not true.
it's not true. I tell people a public defender is, like you said, overworked. You probably will not get a call back as quickly as you would if you call my cell phone. You might not get the expert that you want. Their office uses specific people that are paid by the county. But I mean, these are resource issues. These are has nothing to do with the person's capabilities as a lawyers. They're much finer lawyers than some other lawyers I know that are in private practice. And I actually tell
For
people,
sure.
when people say to me, well, I can't afford it, I don't know what to do. And I'm like, listen, I did the best I can. If you still can't pay this, whatever it is, then don't waste your money on just any private lawyer, because people think out there that a private lawyer is somehow better than a court appointed lawyer. I'm like, even if if a lawyer charges you $3,000-$4,000 for something that should be at a minimum $10,000, that's a red flag for you to run for the hills and go get a public defender, because you're indigent. And at least with a public defender, you're getting a solid attorney. You're not getting some guy who's trying to make his rent at the end of the month. That's literally my pitch to people who can't afford attorney's fees.
That's awesome, Sarah. That's awesome. I'm glad we said that, because I couldn't agree with you more.
Yeah.
I got some burnout friends I should pass that along to as well. Let them know.
All right, guys. Well, it was so nice chatting with you, Jim and Matt. As usual, you make us laugh. I appreciate you.
And what's coming up, Sarah?
What's coming up after the break is a very special guest, my friend Mark OMara. You all know him from the George Zimmerman case. He is wonderful, and he has a lot of experience in death penalty cases. He's never had one person sit on the row, and he's done 12 of them. So he's going to join Jim and I and talk to us about the death penalty and how it applies in the Kohberger case. So stay with us.
And the reason that's timely for us is that this state had filed a notice that they intend to seek the death penalty against Brian Kohberger. And so we're going to get his analysis of that, and I'm looking forward to it.
So stay with us, and we'll be right back after a short break. Hello, and welcome back to The Presumption with me and Jim Griffin and Matt. And today we have a very special guest with us, Mark OMara. Welcome, Mark.
Hey, it's great to be here. Good to see you guys again.
So Mark OMara, you guys all have seen him all over your screens. He's an excellent attorney, and really I'm honored to know him. I got to know him through TV. He's a practicing criminal defense attorney like me and Jim in Florida since 1982. He started as a state prosecutor, then crossed over to the better side. He's among a very select few in Florida who are certified in the field. And by the way, that means you do extra work. You have more experience. You take another test. It's crazy. I try to avoid that. But anyway, he practices in both state and federal courts and consults with other attorneys on trial matters. Mark led the high-profile defense of George Zimmerman, and that's probably how most of you got to know Mark. Very controversial case. We still talk about it today. Pops its head up here and there in other stories. And he was also a CNN legal analyst since 2013, although now the season of CNN legal analysts has pretty much ended. But that's where I met Mark. And we shared some very important conversations on that platform, including on the Murdaugh case, which was Jim's case. Now, my favorite thing I learned about Mark's work is that he started a nonprofit organization. I didn't know this until I read his bio, called Justice Outreach, designed to identify and fix problems with the justice system. And we have tons of those, particularly in the juvenile justice area. And he's an advocate for change in state and national laws that lead to over-prosecution of American citizens. And can we put a picture of Mark, the picture that
Yeah, I was going to say, in addition to all the credits you've listed, I saw this picture and I thought, a second career, perhaps, as a Bowie impersonator. I'm not sure, though.
Oh, nice. Very nice.
That's good. That's good.
Have you been told that you look like David Bowie since you changed your hair?
Have not gotten that yet, but somehow, some way, I'm going to pay you all back for that.
All right. Well, Jim and I have been digging into the Brian Kohberger case. There's a lot of developments in that case, and we wanted to sit with you today to talk to you about the issue of death penalty. The state filed a notice that they're going to seek the death penalty. I know that you've defended about a dozen or so death penalty cases, and none of your clients ended up on the row. So we want to definitely hear about that and how that played out. But, people say when these things happen, they say, oh, the guy got lucky. He got off on a technicality. And I always like to remind people that these are procedural deficiencies. Sorry. And so, definitely we want you to share with us how it worked in your practice. But on Kohberger, Jim, we've been doing this a lot. We've been talking about this case. There was this notice of intent to seek the death penalty filed by the state. What I kind of want Mark to start off with is, does the intent to seek notice mean that they actually will seek the death penalty?
So the quick answer is no. But if they ever want to seek the death penalty, they have to give notice. So the notice is sort of that procedural requirement to say to the defense, we are looking at seeking the death penalty or going to seek the death penalty. We can change our minds against it down the road. But right now we're seeking the death penalty because they have to give the defense notice, because that kicks in a lot of other requirements for what the defense then has an opportunity to do, whether it's start building up additional experts, look at additional information, getting ready for now a death qualified jury and whatnot. So that's required, but that doesn't require the state to seek the death penalty forevermore. Matter of fact, when you look at the last sentence or two on that notice, it says, look, we'll continue looking at potential mitigation or other factors to look at. We may change our mind, but right now we're seeking death.
So, Mark, we addressed this in the Murdoch case. I mean, that issue floated around for a while, and we were never very concerned that they would seek the death penalty, frankly, because of getting a death penalty qualified jury that allowed us in South Carolina to inquire through voir dire more invasive questioning than we're otherwise entitled to. What's been your experience with picking a jury in a death penalty case? Do you get more information about the jurors?
Well, yes, you get a lot more information. Exactly. The reason why, obviously, is because we know in a death penalty case, should the death penalty be imposed, there's going to be, at least in Florida and many other states that have death, there's going to be an automatic review by one of the highest courts. In Florida, it's the Supreme Court. And we get, as the defense counsel, then an opportunity to look into a lot more of the background of these potential jurors, because not only do they have to be, quote, fair and impartial in looking at the facts and applying the law, but since they are going to be death qualified, we get to really look into their background, a little bit of their psychology, their social status of sorts, to try and look at them and say, are you the person who will tell us you're willing to listen and maybe impose the death penalty? But the real danger is with a death qualified jury. We know, Jim, that and Sarah, they are more likely to find a person guilty and then get ready to impose death. And that's really troubling.
So a couple of questions. Is it sometimes sought or the notice filed as a bargaining strategy? And later, recently we saw in the Vallow case, for example, it was the notice was filed, but then they took it off the table. So is it sometimes a bargaining strategy?
Without question. Yeah, okay. Without question, it is to scare a defendant into resolving the case without getting in front of a jury. If you remember 12 years ago, the Casey Anthony case, they sought the death penalty in that case for a couple of reasons. One, they didn't want Jose Baez trying the case by himself. He wasn't death qualified as a lawyer. They wanted somebody else to come in and maybe calm things down. Didn't work out that way. But that was another strategic reason that they brought in the death penalty, even though I don't think anybody who looked at the Casey Anthony case really thought it was a death case.
And how much does like in Kohberger, and I'll ask you more specific questions about this case, but the victims' families have been, especially Gonsalves's father, Mr. Gonsalves, has been really gung ho about the death penalty. And in Idaho, Kohberger would face the firing squad. I mean, I had to actually look up the fire. I kind of knew what it was, but I had to look up and see exactly what they do. And it was just, it's 2023. It was really scary. But anyway,
They actually do a firing squad still?
yes.
Well,
What?
yeah, if they can't find the drugs, then the alternative is now firing squad. And I think what they do is they leave one barrel, one gun with a blank so that you don't know who it was who actually killed him or something like that.
Mm-hmm. Yeah,
Right.
exactly.
So Mark and Matt, we've had that experience in South Carolina. Actually, I mean, there's 7 states I now understand have enacted legislation because of the frustration with the ability to execute people through lethal injection, getting the drugs. And so what the states have, 7 states have enacted as an alternative, the firing squad. I'm not sure if you're aware of this, Mark, but in South Carolina, that's under an injunction as to whether that violates, cruel and unusual punishment and some other state-led constitutional provisions. But yeah, so there's 7 states out there who have like gotten real frustrated with the inability to execute defendants who've been convicted because they can't get the drugs, and so that's
So,
a trend in death penalty cases for sure.
so the how much does the victim get to have a say, if at all, in whether or not a guilty defendant could get the death penalty?
Well, look, in most states, prosecutors are elected like they are in Florida. Matter of fact, Florida just passed a constitutional amendment to give victims even more rights than I think they have in any other state. It's constitutional now that they have a right to be involved in the substantive matters of a criminal case. But, if you think about it, whenever, particularly with a multiple murder case like this, there's no real disincentive to seek death, right? A prosecutor gets to look, law and order, very tough. We have multiple deaths. They do meet several of the criteria under Idaho statute for aggravating factors. So it's almost, why not seek it? You get the benefit of now the victims' families and general public for that matter, are happy with you. Everyone wants Kohberger to seek the most serious sentences possible. So it's almost a no-brainer. And then again, you open up the opportunities to maybe bring it off the table as far as a plea negotiation or whatever else.
But so in Kohberger, and I know there's a gag order, there's a lot we don't know, but we do know, some important facts. In your opinion, and reading the Idaho statute, what do you think are the most important aggravating factors that would support the death penalty if he was found guilty?
Right. Well, the easy one is multiple murders, that more than one person was killed during that spree. So you have that, the heinous, atrocious, and cruel. Yeah, I think that's a questionable one. The way that they all died was not in and of themselves heinous and cruel, like we have seen in other factual cases. But they have that. The fact
I'm going to push back on that. If that was not heinous and cruel, then what is? They were all stabbed.
Sarah, every murder is heinous and cruel. I would.
No, I know, but I'm asking Mark for all the people out there on our Twitters who are saying, "Oh, they were stabbed. Right. 4 people were stabbed." So, how do you differentiate between that and something that's? Give me an example of what you would think.
Give us an example of a nice murder. I'd like a nice murder.
That's right.
Out, please.
Exactly right.
Yeah, a nice non-heinous murder is shooting somebody once in a place that's going to kill them heart or brain. So that's really non-heinous, right? But look, I agree that when you stab somebody, there's more viciousness to it. However, if we're going to compare that to something that's more heinous, right? Why do I say this is not necessarily heinous? Is we know of those murders where it includes rape, ongoing sexual battery, the death is slow, the death is intentional, the death is like, you owe me money or drug money, and now I'm going to kill you slowly. There are many, many more heinous ways to kill somebody. He actually dispatched those people, from what we can tell from the forensics. And again, we don't know a lot, but it seems as though those people died quickly and not in a way that, we define under the case law that talks about heinous, atrocious, and cruel, which means I intend not just to kill you, but to do it in a way that causes more pain.
Mm-hmm. No, you're right. And this is now coming back to me that according to the reports that they had all been partying, they were pretty much numb and half asleep, if not completely asleep. So it looks like the attacks were, I guess, like you said, not as heinous as they could be.
So let me jump in, Mark.
Yeah.
You mentioned earlier, about when they seek the notice when they file the notice of a death penalty case, that you get death penalty qualified lawyers. And tell us what that's about.
So here's the thing, and specific to Florida, but I know with other states that I've helped other lawyers out.
It's same in South Carolina, same as Iowa also. Yeah.
Yeah. In order to be the defense attorney for a death penalty case, you have to have an extra level of competence and abilities. Matter of fact, I'll use Florida as the example. You don't get to do a death penalty case as first chair unless you sit on at least 2 as second chair. Also, you have to have gone to some additional training. We call it life over death training and certain things like that train you how to handle death penalty cases. Because look, if criminal defense...
Yeah, so I mean, I tried the Murdoch case. It's a murder case. I'm not death penalty qualified. What do I lack?
So what
that's a bad question.
Careful.
Well, let me get my list out.
I watched you in trial, so you lack nothing.
I lack a lot. I know I lack a lot.
Yeah. Asking the question about death penalty, for example, unless you have that training, unless you sat and watched another lawyer do it a couple or 3 times, you may not know how to pick or qualify a juror as a death penalty qualified jury. You don't know what questions to ask as much. You can read it off a script, but really having that idea, that concept, and also knowing how to present and argue to that jury the difference between factual guilt for what we call, the fact penalty or the fact phase, as opposed to keeping that jury listening to you for the penalty phase. And I will tell you that nuance of how to maintain your own credibility and therefore a little bit of credibility on your client to get through the fact phase, but still maintain their willingness to listen to you in penalty phase.
Oh my God.
That I think takes a lot of practice and a lot of finesse.
Wow.
And you've done it 12 times, which I'm going to get to at the end of the segment. One thing I think the viewers would want to know from you, Mark, is just based on what we know so far in Kohberger, what are the aggravating factors and what are the mitigating factors? I know we don't know a lot about him, but what would it take for the defense, if he's found guilty, if he's even the right guy, to be, to mitigate the death penalty?
Right. So we know the aggravators. We talked about them a little bit. I think there are enough aggravators that if he was found guilty, given death, that the Idaho Supreme Court could uphold it because there was enough aggravators. Right. Now let's talk about the mitigators. So it troubles me that the Idaho statute doesn't mention any specific mitigators. Florida has about a dozen specific statutory mitigators. They give you some insight, but more importantly, if you think about it, they tell the jury that these are good mitigators, right? Florida says, here's a dozen of them. These you should consider. Idaho sort of says, throw out whatever you want, give it whatever credibility you want. So what do? Obviously, we always look at mental health, whether it's true insanity. I don't see that here, but at least that mental mitigation, right? That he was abused as a child, or he has mental health difficulties, or he has these real identified, maybe pre-existing mental health.
Does drug addiction count?
In Florida, we say it doesn't count because we consider in Florida that that's a voluntary intoxication of sorts, right? You decide to do drugs, don't come up and tell us we should forgive you because you use drugs. The
Yeah,
problem
but
with
addiction, I mean,
yeah,
I'm sure Florida knows addiction has a code in the DSM code.
but we're talking
That's
Florida.
voluntary too, Sarah.
Oh yeah, that's all. Okay, sorry, Matt.
That's the
Sorry.
problem is Florida. We did away with what used to be called diminished capacity. If you're not insane, you don't get to tell the jury at all about your mental health concerns in the fact phase. So with Kohberger, the problem with it is that none of what we have seen of him to date, from his social media that's sort of creeped out there and whatnot, suggest this real, mental health concern. At least not yet. Again, the defense knows a lot more than we do, but I haven't seen, the craziness that we've seen with some of these other killers where all of a sudden you look in social media, you find their 40-page manifesto, or you start, you watch them go down the rabbit hole of craziness in the dark web or something. So I haven't seen any of that yet with Kohberger. It's going to be difficult to, come up with really good mitigation.
Well, the interesting thing is that as much speculation as has gone on that, we've got FBI profilers looking at every move from his eyebrow to the way his eyes, I mean, you name it, they've not only convicted him of the quadruple homicide, but also that he's a serial killer, that there's these other murders. There's no evidence of anything, but that he's killed all these other people. So, but we've seen nothing about, they did say something about at some point he was addicted to heroin or something, and but nothing really substantial about or any interest of knowing, what might have been like in terms of his development and like you said, any history. Can the death penalty ever be imposed by the court, just by the judge? Like eventually?
Yeah, actually, in Idaho law, the defense has the right to waive a jury. And if the defense waives the jury, and in Florida, the state has to agree. I'm really not sure about Idaho. But if the jury is waived, then it is just up to the judge to impose. But I have to take my defense hat off for 1 second, and I shouldn't say this out loud, but I'm going to. Does anyone else think that Kohberger looks a lot like Ted Bundy?
God. Mark.
Yeah, you're right about that.
I'm sorry, but take a look at the pictures.
Yeah.
So I'm not sure he's convicted yet. I presume him innocent. But Mark, I really want to know from your experience level, in death penalty cases, does a jury apply a heightened standard of proof on the guilt phase? I mean, I know the standard is a proof beyond a reasonable doubt, but what the hell is that, right?
And is there unanimity required also for the death penalty?
So let me answer Jim's questions first. Yes, I think they do, because I really think that once you get that death penalty jury qualified as a death penalty jury, that hopefully the defense counsel has done a good job to let them know, look, this is as serious as it gets. This state is going to try and kill him at some point. You better be really certain, not just when we get you to penalty phase, but when we get you to the fact phase. So yeah, I do think a properly defense qualified death penalty jury will hold the state to an even higher burden because they know that the penalties are ultimate.
Higher burden, okay. Right.
I think an even higher burden. Now, in the same sense, the other side of that same coin is what we talked about briefly earlier, which we know that death penalty juries are more likely to convict, because if they get to the point of saying, yes, I can impose death, they're already more law and order. They're already more state oriented. So it's really, there's a coin with two sides. And, the hope is that if the defense does a good job, then they're going to be more sensitized to the reality of it. If the prosecution does a better job, they're going to end up with jurors who are more willing to convict, and then they're more willing to kill.
And you need a unanimous verdict, right? A unanimous finding. So
I must confess, Florida, we just changed it to the answer is no.
Oh
yeah. We this is Florida. Yes. So
So is Florida a recommendation state that they recommend and the judge imposes it, as
that is
Right.
opposed to
How does
some
that
state?
work?
that is correct. So in Florida, fact phase, penalty phase, recommendation from the jury to the judge. The judge has to give the recommendation, quote, great weight, whatever that is, but can override it either way.
What
What about,
about in
I mean,
Idaho, though? What about in Idaho? Do
do
we
we
know?
know? I haven't looked at that.
I'll be honest with you, I don't know if it's, I don't, my understanding is that the Idaho statute says that the jury recommends to the judge, but I don't know today whether it's unanimous or not.
And
We'll check
recommends
on that.
means that, I'm sorry, one second. Recommends, and the judge, if the judge doesn't want to go along with it, then it will not be imposed, right?
That's correct. Yeah, the judge is the ultimate sentencer in Florida, definitely, and I believe
So,
in
so
Idaho as well.
let me ask you this. I mean, I don't know about you guys, but I only once in almost 20 years did a bench trial, and it was a court martial. And my client was an Air Force guy. It was a rape case, and it was really. I mean, I was shitting my pants just doing that with just the court. But people had told me, people that had experience doing court martials had told me that no, it's very different. These judges really have seen real crime, and they'll read through the BS and all that, and it's actually better in that context. And so anyway, I did it. The result was great, whatever. But I can't imagine in a death penalty case, especially when it's a recommendation that the judge may not go along with, why would you waive a jury?
So I just did some multitasking. The jury has to find unanimously at least one aggravating factor
Okay.
in order to recommend death. They can't find it unless they come back and say, we have found this factor unanimously.
In
Right.
Idaho.
In Idaho, yes.
Okay, so then why
And so
would
you've got
you
4
waive a
murders,
jury?
so that would be.
Yeah, that would be enough. That one, as long as the all 12 we find this aggravating factor, more than one person was killed, then that, and they come back and say, we found it unanimously, then death penalty would be appropriate as a recommendation to the judge.
Sorry
So
to be
Sarah, we have had a number of cases in South Carolina where murder cases where the defense have waived a jury trial because they think they would get a favorable result from a trial
because
judge
that's because
on
it's a
death.
boys club down there. It doesn't
But
work
guess
like
what?
that in
But
LA
guess
and
what?
Florida.
It has never worked out.
Yeah, because
It has never worked out.
down in South Carolina, strange things happen.
I
I
don't,
know.
When you
But
have drinks with the judge, I've heard that it gets you, pretty far along. But
I
I'm just
actually
saying,
waived a jury once in a death case,
I
which,
plead the fifth, by the way.
all
by
right,
the way, is scary. When you waive death or waive a jury in a death penalty case, you better take out your bar card and just put it on the table,
yeah,
because if
Right.
you waive and then they get death, you've taken 15 years off his appellate life. And
yeah.
we tried the case to a jury. They hung. We had a judge who had only imposed a death penalty 3 times before. 1, because the guy literally asked for it. 2, because there was no way not to. And another one, a little questionable. But Judge Frank Haney, we waived and went to him directly. And he gave him multiple life sentences.
Right.
I
So,
mean, really,
wow.
I
So you
mean,
got to know the judge, right? You got to know
Oh,
the
yeah.
judge.
Oh, yeah. Because, again, that's a scary thing to do, to take some literally 15, 20 years off his appellate life if we had been wrong.
So, Mark, let me ask you. I mean, you've been there, done that. I've never
Yeah.
have, but I mean, you're trying 2 cases. You're trying guilt and innocence,
yeah.
and then you're trying
Death and life.
life or death, right? And so, and it's the same guy up there, and so I guess you have to make a decision, guilt or innocence. Are you going to come out as the bulldog fighting for your client's innocent, or are you going to try to maintain integrity with the jury so that you can stand up and beg for mercy? I mean, what's the play there?
Well, and that's the nuance that you really
Yeah.
have to be aware of, because let's say with Kohberger, and we don't know the facts at all, but let's just say that forensics come out and the DNA is perfect. Let's just say that it is unquestioned. Well, let's take Kohberger off the table. A client of mine, no question, he or she did it. Facts are obvious. If you walk in there and say innocent, 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 can't prove, can't prove, can't prove, and thereby lose your own credibility with the jury, such that they just think you'll do or say anything, and you have no integrity whatsoever, then by the time you get to the penalty phase, they've already turned their ears off. They're not listening to you at all. So the balance is walking in and going, let the state prove their case, make them prove their case, object when it's appropriate to object, argue what you can as far as having proven reasonable doubt or circumstantial evidence or whatever else. But I do think it's utterly important to maintain your credibility so that when you get to them and say, he's guilty, got it, save his life. That if you're going to have a chance of convincing one to several of the jurors of that, you have to have your credibility intact.
So
Does that put you in conflict with your client? I know Dylan Roof here in South Carolina, who was, murdered.
The church.
It's awful. But he was really advocating his innocence in some degree. But does that put you in a conflict with your client sometimes?
Yeah. I mean, bottom line, you have to follow your client's lead. You're the advocate for him. You're his gladiator. So you don't get to ignore him or her. But, those are those hard conversations you have with, look, this is what I do, not what you do. This is how I do it. Not, you don't know how to do it. And try and convince them that saving their life in a case where facts are obvious, saving their life is the battleground, arguing innocence, or maybe just convincing them we have to stay mute during the fact phase, and then get into it during the penalty phase. It's and I've had clients. I had one client who refused to talk to me for the past 3 months before the trial because I had that coming to Jesus meeting with him. I said, you have 2 surviving victims. You have 3 victims who have passed. We need to avoid you getting death. And he wouldn't talk to me.
I'm not asking any specific conversation, but I don't think it's irrational for a client to say, fight like hell on guilt or innocence. If I get the death, I don't care. I don't want to spend 40 years in prison. I mean, does that come up?
Yes, it does, because, and particularly don't forget, most of the, you're talking about clients who are, in their 20s usually, right? Or maybe their 30s. That's when this stuff happens to people usually. They're not all that mature, maybe. They may not even be that well educated. And I will tell you, you tell somebody, hey, I'm going to do a great deal for you. I'm a really good lawyer. If we win, if I do everything I can do, you will die in prison. Because that's what happens in Florida. This is not a, get out of jail in 10 years. Florida, the only way you get out is in a pine box. So, yeah, you're sort of right, Jim. Telling a client that, hey, I'm going to do a great job and avoid death so I can keep you alive longer in prison doesn't sit very well, on the brain of a 25 or 30-year-old necessarily.
Such a hard conversation to have, as with a lot of our conversations. But one of the criticisms in Kohberger, I think his public defender, who is death qualified, one of the very few in the state, because it's a small state, has done a pretty fine job. And, this is just based on the papers that I download every so often and I read. But there was a lot of criticism about how much she's getting paid, which is ridiculous. And, that they added another lawyer on the team, who is a mitigation specialist. And then they had dug up that lawyer's old LinkedIn that she at one point in time was a real estate lawyer. And so they were criticizing her for being and I'm like, people just don't update their shit, So long story short, they were just on him about the cost of this prosecution and that there's a mitigation. I mean, is it rare that you would have more than one attorney, especially one that specializes in mitigation?
Oh, you have to have, in my opinion, it's malpractice per se to not have at least 2 lawyers representing somebody for the death penalty. One reason is you may have to carve off the one who's going to be the jerk at fact phase and still have them maintain that credibility we talked about earlier on the one who's going to come in for penalty phase. So without question, you have to maintain that. And look, it is thousands of hours to handle a death penalty case properly, because you have to, everything in the mitigation side of it, the avoid death side of it, we go back, prenatal. We go back to whether or not the mother of the client had fetal alcohol syndrome for drinking we start there and go all the way through it and talk to the 6th grade teacher who, he was cutting his arm with a pencil, or whatever it might be. So we have all of that you have to look at, and that's hundreds and hundreds, if not thousands of hours. And one lawyer, I don't think, can or should take on a case of this magnitude.
And given that you mentioned, typically these are clients that are younger, don't have as much experience in life, etc. Have you always been, sorry if I'm butting into your business, but has there been instances where the court and the county pay you because this is not a client who can afford the thousands of hours it would cost him to defend?
I've never had a privately retained death penalty case.
Okay.
They can't afford it. Think of the numbers, just an hourly rate and times it by 1,000. Nobody can afford that. But if I can spend a moment, we talked about the cost of it. I had a case up in a rural county in Florida, and back then, it's a little bit different now, but the county has to take on a lot of the cost. Well, it was like $300,000 or $400,000 that we knew the county was going to have to spend, not just on us, but on experts, on blah, blah, blah. We went to the family and to the prosecutor and to the county and said, look, this is going to cost you $500,000, county, and you don't have it. We actually got them all together in the same room and convinced them, weird as this is going to sound, the county needed a new fire truck. It's $380,000 for a fire truck. We actually got them to put a plaque on the fire truck in honor of the victim of the death, and got them to waive death, because it's so much better to spend their $400,000 or $500,000 on something that they needed than to, quite honestly, waste it on defense counsel or defense costs.
Wow.
We got them to do that.
Wow.
That's amazing.
That's awesome.
So let's end with, I'm very curious, your most notable death penalty case that basically you thought, the jury's going to come back with a recommendation, and they didn't.
So that was what I talked about earlier. This is a guy who was accused of killing somewhere between 5 or 6 and 11 women up and down the I-4 corridor in Orange County, Florida, that area. We don't know how many because they weren't all found. But we tried that case to a jury, and they came back hung. And I'm telling you, it was amazing to us. The reason why they came back hung 11-1 was the one person was what we call a We Care suicide prevention hotline guy. And he would not find him guilty of first degree. And he would not find him guilty of second degree. He wanted manslaughter. The other 11 came down to second, but would not go to manslaughter, which is why they hung. I found this all out afterwards, obviously. I would have knocked on the door and said, we're okay with second, but nobody asked me. But that's the one that I waived going back to just the judge. And that was the most notorious case, because I'll tell you also, that was the guy who wouldn't talk to me for the 3 months leading up to the trial. And it's a little bit difficult when your client ignores you. And there's more about that case, but that's maybe for another day.
So Mark, you've hit on some really important things that go to the heart of our podcast, which is, even though it's a crime podcast, Jim and I were inspired to do this together because of how incredibly eroded the presumption of innocence is, and the role of media and this whole obsession with true crime genre on the presumption of innocence. And of course, you represented Zimmerman, so you have a lot to say about that. And then you also hit on, mental illness in terms of mitigating factors. But obviously, as we all know, it plays a part in almost all of our cases. I've never had a client who's been 100%, comes from 100% solid family and has the perfect family, and then decides to commit crime. So it's a big passion of ours to sort of, educate the larger public about these issues that we encounter. And so we hope that you come back and join us. Can we bother you again and again and again?
Absolutely. I would love to. No, this is great. I love doing this.
Yeah. And Mark, I just want to tell you, it's been an honor talking with you. I want you to know, Sara and I were on Good Morning America very recently, and she said, we represent the bad guys, and they think we're really bad guys, but we sleep well at night. I just want to know, do you sleep well at night, and why?
I really do. First of all, I love this stuff. I am so glad that I got here. I can't make believe the path was perfect, or intended when I was 12 or whatever, but I love doing this work. I really enjoy representing people and helping them through. When I get all uppity, people say, "What do I do?" And I say, "I'm, quality control for the criminal justice system." Or, "Well, how do you represent those people?" No. I represent the Constitution. And because I do that, you get to enjoy yourself. Go ahead and drive around the street, not worried about whether or not a cop is going to pull you over for no reason and break into your trunk. Just thank me when you get a chance. That's sort of the way I look at it.
I know it's a conversation we have too. And it's like, the common question, well, how do you represent this guy when he's admitted to you that he did it? And it's like, but it's not about the guy. It's about the process. It's about the Constitution.
And most of what we do really is damage control. Look, yes. I very few times, probably Jim and Sara, does someone walk in totally, completely innocent, mistaken identity. I was in Hawaii.
Right.
No, basically it's damage control to say something happened. Maybe they didn't do it right, so they don't deserve their conviction, or they deserve their conviction for something else, or it's mitigation of sentencing, or it's avoiding that god-awful felony conviction.
Isn't there, it's statistically out there that more innocent people suffer wrongful convictions than guilty people walking out of a courtroom free. I mean, it's just a fact. So I think everybody can sleep really well at night and know that we're all safe and we do good work.
Yeah. Right now, I think the number is 168 reasons that the death penalty sucks. And that is how many people were exonerated. And we know what that means. It's not technicality, not they got off because of good lawyering. They were factually innocent, yet were convicted and given the death penalty. And after that happened, 168 of them across this country were found not to have committed the crime by independent, not by some defense lawyer, by independent evidence. And that means it ain't working.
Yeah. I agree.
Mark, this has been awesome. Thank you so much.
It's been fun.
Thank you so much, Mark. Thanks for joining us. And we will be asking you to join us again, I guarantee. And Jim, until next week, we are going to
rest.